Welcome back to the Constitutional Clarion. Now, as a constitutional lawyer, I've known for a long time that New Zealand was once part of New South Wales. But what I didn't really know was, well, for how long? How did it become part of New South Wales? Did the New South Wales government and parliament ever really govern or legislate for New Zealand? It was all a bit of a mystery to me. And I didn't really find out until I did a speech which dealt with related issues last year. So I thought, well, it's probably a mystery to many Australians and probably some of my viewers as well. So I thought that would be a good subject for a constitutional clarion. So this is a broad brush approach to that New Zealand history. Obviously, there'll be other perspectives on it as well, so I encourage you to look for those. But this is just one view of what actually happened. Now, from my perspective, what's most interesting about it is that we see quite a different view of the British and their role in colonisation and their relationship with Indigenous peoples from the view that we've ordinarily seen. So we think of European colonial powers in the 18th and 19th centuries as being focused upon acquiring as much territory as they possibly can to expand the limits of their empires. Yet this story is one of the British government actually being very reluctant to claim sovereignty over New Zealand and until it was effectively pushed into doing so. So, New Zealand, from a European perspective, was known to colonial powers from at least when Abel Tasman sighted New Zealand in 1642. But it was more than a century afterwards when James Cook was sent out on his voyage of exploration to find the Great Southern Land. But in his instructions, he was given first instructions to go to New Zealand and to map it. Now, Cook did go to New Zealand and he claimed the North Island of New Zealand on behalf of the British on the 15th of November 1769 at Mercury Bay, and the South Island on the 31st of January 1770 at Queen Charlotte Sound. Now, of course, in reality, neither claim was actually effective because you have to give substance to that kind of a claim by actually taking control over the relevant territory through law and settlement of people and those sorts of things. So these kinds of claims of sovereignty were really just like a game of first dibs. You know, here is my claim that this one is mine, and you know, maybe I will try and defend it with my maritime forces if you try and claim it. But really it was just about discouraging other colonial powers from settling that particular place. Now, when the British first arrived on their first fleet in Sydney, Australia in 1788, Governor Phillip's commission extended not only to the entire eastern half of Australia, so all the way from Queensland right down to the bottom of what we now know as Tasmania, but it also went to all the islands adjacent in the Pacific Ocean within the same latitudes that this New South Wales, top to bottom covered. As New Zealand fell within those latitudes, the question was, well, how far away does adjacent extend? I mean, obviously it can't extend around the entirety of the world, so what's the limits? And does that mean that New Zealand was sufficiently adjacent to Australia to fall within the initial claimed settlement of New South Wales? It seemed that the early governors of New South Wales did consider that their jurisdiction extended to New Zealand, but the British government itself made no clear assertions of sovereignty and deliberately left the position ambiguous. Now, without any formal process of colonisation, Europeans just began to settle in New Zealand of their own volition. Now, some of these were whalers and sealers, and they were involved in trade, but others were escaped convicts from New South Wales, runaway sailors, and anyone who was trying to avoid the law. New Zealand became quite a dangerous place, both for Maori and also for settlers, who sometimes came into conflict. Often muskets and gunpowder were actually exchanged for land, and that resulted in the intertribal Maori musket wars and the destruction and enslavement of Maori tribes by each other. Now, in 1813, Governor Macquarie in New South Wales tried to impose order by sending a Justice of the Peace to New Zealand. This was such an ineffectual thing to do, it was met by ridicule by the settlers and achieved nothing. Now, missionary societies also had a go at imposing rules of behaviour, but New Zealand soon became known as a centre of vice and lawlessness. And this was because technically there just was no law that bound those European settlers there. There was no policing and there was no punishment of wrongdoing. So you can imagine what it could be like. Now, the British settlers in New Zealand began to demand protection of their lives and their property. While the British Parliament denied that New Zealand actually did fall within its dominions, it did pass a law in 1817 to punish murder in New Zealand, and it conferred jurisdiction of the New South Wales Supreme Court to try offences that had been committed in New Zealand. But again, these weren't effective because unless the person happened to be in New Zealand in order to be charged and prosecuted, then, basically people could get away with murder in New Zealand. Now, after 13 Maori chiefs petitioned King William IV for protection, another ineffectual attempt was made to impose law and order in New Zealand in 1831. And this was by sending an official British resident to New Zealand. Now, this was a position that was actually paid for, most reluctantly, by the New South Wales government, which didn't want to do so. And the man chosen, whose name was James Busby, was nominally part of the New South Wales government administration. But he was ill-suited to the task, and again, this project failed. Pressure mounted on the British government then from three different sources. First of all, we had the missionaries. Second, we had Edward Wakefield's New Zealand Company, through which he wanted to run an organised system of colonisation, which would be funded by selling the land in New Zealand. And thirdly, we had the threat of colonisation by the French. Now, the British did not want to colonise New Zealand because they thought it was too far away and it was going to be too hard to manage and, most of all, too expensive. But at the same time, they were worried about the lawlessness, and in particular the land grabs that were going on and the risks that were faced by their subjects who were settling there. And they were particularly concerned about what would happen if New Zealand was taken by another power. The French had increased the visits of their ships to New Zealand and then provocatively appointed a Roman Catholic Bishop of New Zealand who arrived in 1838. Now, if you read all the British documents, what the most amusing thing was how much this assertion of Catholicism in New Zealand really agitated the Protestant men in the British Colonial Office. So this was pretty much the last straw as far as they were concerned. In addition, a French citizen had acquired a huge area of land around Akaroa in the South Island of New Zealand with the intention of lobbying the French government to support a formal colonisation settlement process there. So from that point on, the race was on to see who actually managed to claim sovereignty over New Zealand. Now, the British government then wanted to avoid passing legislation to do this because they knew in particular that Wakefield's people were very effective in lobbying British members of Parliament. So any bill that went through was going to be subject to a lot of debate and a lot of amendments. And so they asked the British law officers, well, can you think of a way that we can do this without actually having to do legislation? So the British law officers said, well, actually, yes, you can use your prerogative powers, so they are executive powers that are recognised by common law. You can use your prerogative power to annex New Zealand to the colony of New South Wales. and so that's what they did. So this was done by letters patent that were issued on the 15th of June 1839, which extended the jurisdiction of the New South Wales Governor, Sir George Gipps, over any territory which may be acquired in sovereignty by Her Majesty within New Zealand. Now, British officials thought it would be safer, and particularly in the interests of the Maori people, if this legal power of governance over New Zealand was actually conferred on a government that was distant from New Zealand, that was an experienced government and had no real political self-interest, particularly in the land issues in New Zealand. And so that's why, or one of the reasons, why the power was given to the New South Wales government. Now, what's most interesting is that by 1839, the British had significantly changed their approach to colonisation. In 1788, sovereignty was claimed by the British in Australia by right of discovery, settlement, and/or conquest. There's obviously a debate about that in Australia. But cession had never been at issue in Australia. And it means it's rather bizarre. You keep on seeing all these things where people say, oh, this land was never ceded. Well, that just wasn't an issue here. Unlike many other countries where land was ceded under treaties, it didn't happen here. So we're effectively saying something didn't happen here that didn't happen here. Anyway, so in Australia, cession wasn't an issue. Now, the claims to sovereignty that were made by both Captain Cook and then later Governor Phillip, again, weren't effective claims until you actually gain control over the land and the people there. So you have to have laws that effectively govern those areas, and that's how you actually gain real sovereignty. So again, these are really just first dibs type claims, but nonetheless, that was how it was done in Australia. But by 1838, the British policy was actually to seek to obtain sovereignty first by way of cession through treaties, if that was possible, with the fallback of using discovery, settlement, conquest, etc. So the British sent out a fellow called Captain Hobson to New Zealand to negotiate with the local chiefs for cession of territory. And once he succeeded in that, he was going to become the Lieutenant Governor of New Zealand, but the Governor of New Zealand would still be the Governor of New South Wales, Sir George Gipps. Now, Captain Hobson first arrived in Sydney and met with Gipps, and while he was there, proclamations were issued to, first of all, prevent further land sharking, as it was called. So this was gobbling up vast areas of Maori land, and also to establish commissioners who would review past purchases of land in New Zealand to ensure it had been done fairly. When Hobson arrived in New Zealand, he quickly proceeded to the negotiation of the Treaty of Waitangi, which was signed by 45 chiefs on the 6th of February in 1840. Now, the English version of that treaty ceded all rights and powers of sovereignty exercised by those chiefs in relation to their territories to Queen Victoria in exchange for protection and the rights and privileges of British subjects. Now, while the treaty was much discussed over a 2-day period, and there was a Maori translation of the treaty, it has been since argued that there were no Maori terms for such abstract concepts as sovereignty, and that genuine informed agreement had not actually been given to the treaty. In any case, these chiefs only covered part of the territory of the North Island. So Hobson then went out with others and travelled around the North Island seeking other signatures from chiefs in order to achieve cession of the whole of the North Island. But fearing the French would claim the South Island, Major Bunbury was sent there to finish the cession negotiations. Now, he gained some signatures for the Treaty of Waitangi, but upon seeing some French ships in the harbour, he basically got spooked and he decided to declare sovereignty over the entirety of the South Island in June 1840, rather than just those parts that had been ceded. Now, in doing so, he did beat the French, who actually did send settlers to colonise part of New Zealand, but they arrived at Akaroa in August 1840 to find that the whole of the South Island had already been claimed as a British dominion and had been annexed to New South Wales. Now, meanwhile, in the North Island, not having yet heard from Bunbury about what was going on down south, Hobson had to respond to another crisis, and that was that Wakefield's New Zealand company had decided to set up its own government and claim its own colony based in Wellington. So on the 21st of May 1840, he then declared British sovereignty over the whole of the North Island by cession, and also over the South Island and Stewart Island on grounds of discovery. Now, once his dispatches had reached London, the British government then declared on the 2nd of October 1840 sovereignty over the whole of New Zealand. Now, all those good intentions about gaining cession had been abandoned in the face of threats both from the French and from the New Zealand Company. The claim of sovereignty, again, was there to deter competitors, but was still, in law, not really enough. There had to be legal control over the people and the land. So sovereignty was in fact obtained by settlement and occupation, as well as by the imposition of law and the effective enforcement of law. Now, the annexation of New Zealand to New South Wales was not popular in New Zealand. The settlers there did not want to be tainted with the convict stain of New South Wales. And equally, the people of New South Wales were unhappy at having foisted upon them the burden and expense of governing a new colony, which was a long way away. So both sides were actually relieved when the British government slipped into a bill about the New South Wales Constitution in August of 1840, a provision which allowed for the separation of New Zealand from New South Wales and its establishment as a separate colony. The British government then issued a charter for erecting a colony of New Zealand, and so that was done by letters patent on the 16th of November 1840, and it established New Zealand as a separate Crown colony. And this was proclaimed to come into effect in New Zealand on the 3rd of May 1841. So the period during which New Zealand was formally part of New South Wales was actually very brief, arguably just the last parts of 1840 and the beginning of 1841. But in practice, there had been a sort of a de facto control or relationship for some decades before that. Thank you for watching the Constitutional Clarion. I hope you found that interesting. I certainly did find it interesting when I found out all about it. So thank you for watching, and hopefully I'll see you next time. Goodbye.